So, Scott, you have written a piece over at the American Prospect as part of the Day One Agenda project. Really, I think it's fair to call it. And if folks have not gone and checked this out, I think it is one of the most important journalistic tools, or I should say, piece of journalism that is a tool for activists and progressives. Because we've talked about this on the show in the past as to, the myth in many respects that a president doesn't have that much power if they don't have control, a sort of overwhelming control of their party has in the two houses of Congress, that they can't do anything. And the Day One Agenda lays out, I think it's about 30 off the top of my head, really major initiatives that the next president can take that we all talk about in terms of legislation, but can actually be done with existing legislation if they are so inclined. However, they have asked you to step in and be essentially, talk about the fly that's in this ointment. If I understand it, your piece is entitled, "Wait a minute, could John Roberts block all of this?" So you have to go back in many respects to, I guess, what is known as the Lochner era, but we're really talking about the beginning, the early 20th century.
Right.
Maybe, arguably late 19th century, in terms of a Supreme Court that is pretty well positioned and hell bent from stopping any type of progressive legislation. But tell us what, broadly speaking, how much power does John Roberts have to put the kibosh on a lot of this stuff?
Yeah, and first of all, let me echo, I really hope readers will check out, my editor, Dave Gahan, of course, who's written a lot about these issues, put together this terrific package. And I think it is, that, often, these arguments, and I've been doing this in the internet for a long time, pointing out that presidents are really constrained in terms of their legislative agenda, even when their party does control Congress, that the difficulty of getting coalitions put together could be hard. But a lot of people infer from that, well, then what's the big deal? Who controls the White House? Well, the big deal is it's, the people who work in the executive branch for a Democratic administration are very different than people who work in the executive branch for a Republican administration. And then, of course, judicial appointments as well. But I think the underlying premise of the project is that the president already has the existing statutory authority to do a lot of things, not to do everything. There are problems like healthcare that really do need legislation to solve, but there are a lot of other issues in which, presidents, really can do a lot. And that's where, I fault, as David has argued, the Obama administration, not so much for getting, a much better health care plan, which given the Senate votes wasn't really viable, but you can fault them for not doing a lot more about the foreclosure crisis, which was done with a lot of systematic illegality. And so the next Democratic president really has to be focused on that, that they have to come in. And second term Obama was better on this. I think that he learned, but, it's, in some respects it was too late, particularly given the way the regulatory state works. The next Democratic president really, who we hope obviously will be Warren or Sanders, but, whoever it is, really needs to sort of hit the ground running and really have this. But
and let me just add, much of what Obama did, he did in the last year of his presidency, and because I think it's the CRA, whatever maybe it's Congressional Resolution Act, I can't quite remember what the legislation is, but it allows Congress to reverse those some of those executive orders and some of the sort of directions to agencies that are not quite executive orders, but executive actions. And it makes it much harder to reinstitute in the future. So doing this literally on day one, or at least in year one, is very crucial if the president has, the House anyways. But go ahead. How can John Roberts put the kibosh on this stuff. It starts first with the non-delegation doctrine you're talking about.
Yeah. So, and as you say, that because, the way the Administrative Procedures Act works, the more lead time you have to change regulations, the better chance they have. So the one difficulty is that, and one of the sort of hidden, and last term was really quiet before, this term we're apparently going to get the blockbuster abortion and gay and lesbian rights cases and trans rights cases and other big ones. But one of the sort of hidden cases was a case called Gundy versus United States, which dealt with, the Congress, changed the Sex Offender Registration Act and said that it should be retroactive, but it left it to the Department of Justice to determine, what the timeline should be. And again, this is just an absolutely bogged, and again, I don't particularly like the policy choice Congress made, but that's not the Supreme Court, or, maybe there's a due process issue, but, this is completely bog standard. And if anything, in this case, Congress made a more clear policy choice than usual and simply left some details out to the executive branch. Elena Kagan, in her opinion, upholding it, pointed out that if this is unconstitutional, like most of the United States code is unconstitutional, it's just, like in most environmental regulation works, for example, by, setting really broad objectives and having, the executive branch using the science of the EPA figure out, like Congress doesn't determine how much mercury can be in the water or, what the emissions should be. That's done by the EPA. And these are policy choices that carry consequences. You're a company and you violate these, the Code of Federal Regulations, we call them regulations, but they have the effect of laws. They can set criminal penalties. You could be fined or worse if you disobey them. It's not like they're suggestions. So this is just basically how the federal government worked and has always worked, and I linked to a couple articles in my piece that, it's not, obviously it accelerated, during the New Deal era, but, legislators have always deferred certain policy choices to the executive branch and to the courts. That's just, it's not new. But what was disturbing about that case was, so Kavanaugh was not on the court to hear it. So there were three dissenters, including Chief Justice Roberts, who one would assume is the swing vote, and Justice Alito filed a concurrence, without joining Kagan's opinion, basically saying, that the way the court has interpreted non-delegation for 84 years, this is obviously constitutional, but I'm open to rethink this. So pretty clearly the signal is once Kavanaugh's on board and there's a fifth vote, will restore the doctrine. And I guess I should go back. And so non-delegation doctrine, actually, it literally had a 5-month life in 1935. The Supreme Court struck down two pieces of Roosevelt's, and a part of the New Deal that had already sort of fallen out of favor, sort of not a core of what we, the Industrial Recovery Act, not what we consider a core part of the New Deal now. As being an impermissible delegation. The idea is that, Congress just gave so much discretion to the executive branch that it essentially usurped its legislative authority. And again, that at least was, a fairly extreme level of delegation that wasn't just sort of an ordinary. But having said that, the court wisely abandoned it almost immediately. So, as Alito says, literally in the 84 years since the Schechter Poultry case, the Supreme Court has never held a delegation by Congress impermissible for the obvious reason that there would just be no way of applying that coherently. Kagan's right. That if what Congress did here is
common sense, if you have to defer to the legislative power of Congress, then you have to accept that they can legislate that we're going to delegate this, the details to the experts.
Yeah, and there's just no, Congress just doesn't have the expertise to deal with a lot of these questions. And it's not, the executive power here is not completely unchecked either. They're supervised by the president who, despite some reason, is the closest to being a nationally accountable figure. And Congress can always go back. If the executive branch is doing things that Congress really doesn't like, it's free to modify the legislation. So it's not like it gives the executive branch some kind of absolute power. But that's just basically how government works. It's simply how it's always worked, and it always has to work. But the problem is that it basically, once the doctrine is revived, it'll give a sort of blank slate to the Supreme Court to throw out any regulation it doesn't like, simply because you can make a non-delegation argument about virtually anything. And that's what makes this so dangerous, is that there's just no, it's almost impossible to come up with an example of regulation that you can't claim, that you can always define the relevant policy choice at a level that Congress didn't make it. Yeah, and so the one thing I wanted to say is that, all of these sort of interventions just willfully misunderstand how the American political process works. That I would have less objection to the non-delegation doctrine if it was sort of a European-style constitutional court, where as part of the legislative process, the legislature's considering something, somebody brings a challenge to the court, and the court says, well, tighten up that language, or, that's fine. But in our system, where you can't hear a case until a law has already been passed, what the court will try to argue is, well, all we're saying is that Congress can't do it this way, but it's always, feel free to come back and make the choice more specific. But in our system, gridlock generally makes that impossible. That once the court establishes a new policy baseline, it's very difficult for Congress to come back and reassemble the same coalition.
The Congress hasn't even been able to come up with a new fix for Section 5 of the Voting Rights Act in the 6 or 7 years that has been gutted by the Supreme Court.
Yeah, or think of the Lilly Ledbetter case, in which the Supreme Court basically issued a really bad interpretation of the Civil Rights Act, which allowed, made it much easier for employers to engage in gender discrimination and pay. The first act Obama signed was, restoring, the correct interpretation. But if the opinion had come down 2 years later, it would have been impossible to fix. There's been no, it happened to come down at a time when you had a unified Democratic government, but most times, Congress would not have effectively been able to respond because people who supported the court's misinterpretation would control a veto point. So that's another important thing, is that, basically there's very good reason for the courts to be deferential on issues of interbranch delegation, because, it's impossible to sort of put things back in the box. That's not the way our system works. So basically, the 84 years in which both liberals and conservatives have largely ignored non-delegation doctrine on the court that was wise. And reviving it's going to be a disaster.
All right, Scott, we only have 3 minutes left. I mean, broadly, give us just an explanation. Chevron an hour. These are like a slight derivation of that non-delegation doctrine.
Yeah, and it's not quite because it sort of, whether it's a good or a bad thing will sort of depend more on who the courts are and who controls the executive branch. But traditionally, for a while, the Supreme Court has said that, the court should defer to the interpretations of executive agencies, that, unless the interpretation is just completely unreasonable or unpermissible, that generally the court should not interfere. That as long as what executive agencies are doing is sort of a rational interpretation of the law, then they should defer. And it seems like the Roberts Court is signaling that they're going to do less of that. That essentially they're going to be more willing to sort of replace their interpretations of the law with that of executive agencies. And again, given that Republicans will probably control the Supreme Court under the next Democratic administration, is likely going to mean sort of replacing the interpretations of more liberal executive agencies with more conservative policy views. That won't always be the case, but so it's not as always disastrous long term as reviving non-delegation doctrine would be, but it's still not a great sign for how aggressive the next court is likely to be under the next Democratic administration. So when we talk about these, is there one other? We got about, I don't know, maybe a minute left. I mean, all right, let's put it this way. What precludes them from doing this? I mean, what precludes them from moving the court in this way? Well, I want to end on at least a half optimistic note.
Okay, please.
and it should be kept in mind that even during, the worst periods of the Supreme Court, most progressive economic regulations survived. We remember Lochner because it was struck down, but a lot of other, state regulation was able to survive. So the important thing is, don't going to do it, make them do it. Don't just preemptively give up. Do enact the day one agenda. Do everything you can do and see what the courts will do. And the other thing is, really make sure that the I's are dotted, the T's are crossed. That the Supreme Court is a complicated mix of politics and law. And on issues that the justices feel super strongly about, doing everything as carefully as possible probably won't matter. But there's a lot of other issues on which the justices don't, it's not necessarily the biggest deal. So don't give them an excuse. Follow the procedures as carefully as you can. Do things as carefully as you can. That won't always work. The Supreme Court is political, but don't give them a plausible reason. Make it as hard as possible. Just because the court is likely to interfere with some things doesn't mean that it's going to interfere with everything. And, even if the court is going to issue bad rulings, it's better that you force them to make those rulings than it is to just give up preemptively, that there are political, it's better if the regulations are upheld, but forcing them to strike them down is better than just not passing them at all.
So on day one, that president should make sure they have an attorney in the room to guide them. Scott Lemieux, appreciate your time today.